Hey folks, elder law care attorney Patrick Kelleher. Today folks, I'll be answering the question, what is a trust agreement in estate planning? Thank you for joining us today. Folks, you may recognize me as the author of my book, How to Slay the Four-Headed Beast, or How to Avoid the Metaphorical Four-Headed Monster of Estate Planning and Elder Law. Folks, you can also go to our website, elderlawcare.com, and pick up a copy of the book there and click on the Elder Law Academy tab, because we created a lot of at-home programs where you can learn how to slay the metaphorical four-headed beast of estate planning and elder law, which is probate court, the estate death tax, financial creditors and predators, and the $15,000 per month private pay nursing home. Folks, today I'm going to answer the question, what is a trust agreement in estate planning? Folks, a trust agreement is a contract. A trust is a contract, folks, typically between three individuals, and I'll break it down for you now. Folks, somebody's creating a trust. Think of your trust like a treasure chest. So I have my trustee treasure chest here today before us. Think of your trust like a treasure chest, folks. And a trust agreement or a contract, yes, there are legal documents in there that are very, very important, with very important legal language in there. And the trust agreement typically, folks, comprises of three individuals who created and oversee and are the beneficiary of that trust agreement. And here we go. Number one, folks, is the trust maker. The trust maker is a term that my Elder Law Care Center uses typically when we're creating a client's trust. And you'll also hear some other terms like grantor, donor, and settler. They all pretty much mean the same thing. That is the person creating their trust. They're creating their trust agreement, and they're working with their estate elder law attorney, putting very important terms and conditions outlined, delineated within the four corners of the legal documents that comprise this large estate planning portfolio. So that estate planning portfolio represents your estate plan, and a big portion of that, the engine that drives that estate plan, is typically the trust-centered plan or trust agreement. So the trust maker is a person who creates that plan around your goals, your dreams, your visions, your aspiration, what I refer to as your dream snapshot. Number two, folks, the second role in a trust agreement is the trustee. The trustee is the manager of the trust. And sometimes you can have more than one trustee. Typically, if there's a married couple, Bill and Mary, typically Bill and Mary will serve as co-trustees for each other's trust or trust agreement. And the trustee's job is to oversee the affairs of the trust and follow the instructions in the trust. That's their playbook, and they have what they call a fiduciary duty of loyalty to follow the instructions in the trust, the terms and conditions, to make sure they act in the best interest of whom? The beneficiaries in the trust. That's coming next. What's the third important role in the trust? That is the beneficiaries. Who are the beneficiaries of the trust? In a standard situation, it might be mom and dad, Bill and Mary, trust makers creating their trust. If mom and dad are healthy and there's no cognitive impairments, then mom and dad oftentimes will serve as trustees or co-trustees of their own trust. And number three, when mom and dad are alive and well, they oftentimes will also serve as beneficiaries of their own revocable asset protection trust as well. So yes, folks, they heard it. You can often serve in three capacities and wear three hats when you're creating your trust-centered plan. Number one hat you're wearing, you're the trust maker. Number two hat that you're wearing, you're the trustee manager of your own trust or treasure chest. You get all your treasures in there. And number three, you are the beneficiary during your lifetime as well. So there you have it. It's permissible per trust law to wear all three hats: trust maker, trustee manager, as well as beneficiary. You can be the beneficiary of your trust in a time when you are alive and well as when you are alive and not so well, a time of disability or incapacity. That way your loved ones can legally step into your shoes and manage your financial affairs for you, manage your treasures in your treasure chest to take good care of you in a time of need. So there you have it, folks. That is a trust agreement. And again, folks, as you heard me say before, when is the best time to put the trust agreement in place? That's when you're alive and well. Do not, folks, wait until you're alive and not so well, because that is referred to as crisis planning and not pre-planning. Folks, thanks for joining us today at elderlawcare.com. If you found this video helpful, folks, please scroll down, post a comment, post a question, and a member of our Elder Law Care team will get back to you as soon as possible. Folks, thanks for joining me today. Patrick Kelleher at elderlawcare.com.